to today's webinar on dire consequences of suspension of company by stock exchange and remedies available. Thank you all for joining in our knowledge sharing journey, which we started in 2020 during COVID period. Friends, as you are aware that stock exchange is a manufacturer of liquidity, and stock market is considered as economic barometer of country. Any stock exchange and any equity market is essential for any country of the world. As you are aware, during the COVID, when everything was closed, the stock market was open, and this opening was identified and indicates that this was an essential commodity things or essential work or important work equivalent to the hospitals and other things. So you can understand the importance of stock market, stock exchange, capital market. Now these stock exchanges exist because of the companies. Today we see that total companies on Bombay Stock Exchange is listed around 4,777. Out of this, 3899 they are available for trade, mean they are active company, complied, and everything is okay. You can trade in these companies. There are 878 companies are suspended on the stock exchange. So companies are limited to 3899. You remember when all the regional stock exchange was there, then we have around 10,000 listed company across the country. Highest number was with BSE and NSE, then other regional stock exchange. But when the regional stock exchange was, they have closed it. After that, either these companies have gone to the BSE or NSE, or they have closed down, or they have given the exit route to the shareholders. Now, here the point is the suspension of trading in any shares. It is a part and parcel of any system, because you are listed, you have to follow law, you have to comply, and you have to do the work as per the rules, regulation of SEBI and stock exchange. But if you are not following that, then your company can be suspended. Now, the suspension of trading in shares of listed entities always considered as a bad, and it has a dire consequences they have to face. Besides loss of reputation, the immediate consequences are degrade to Z group, that is a worst category, freezing of Demat account of promoters, resulting in non-scalability of sellability of shares, because promoters' Demat accounts are freezed, so they cannot sell any shares in that Demat account. Continuously mounting penalties, because not only this, penalties are also continuously increasing and adding. If suspension continue for more than 6 months, stock exchange can compulsorily delist the company which result in 10 years of debarment on directly or indirectly assessing the security market. So first they will suspend you and freeze your Demat account of the promoter. And if it is continue for 6 months, that is the law, but the stock exchange always give chance to the companies. If they follow delisting route, then another liability on the promoters comes that 10 years, they cannot come in the market. And this limitation is not only the company, it is on the whole-time director, it is on the promoter and the company promoted by them, and the person responsible for ensuring compliance with the securities law. So you can understand that these all people are debarred and their accounts is also freeze. Thus, we can see consequences are very serious in nature, and it has a far-reaching effect. The objective of the webinar is to deliberate the consequences of the suspension, compulsory delisting of companies, because that is a outcome of the after the suspended company. This is the outcome. And then what are the remedies available? Today, remedies are available, like you have to revocate the suspension and and then pay the penalty or go for the waiver if you have a justified reason. Second is you have to revive this company or restructure this company. The most important point which we will discuss today, that what is the reason of delist, the suspension, how you can remove the suspension, what are the consequences of delisting, and how the suspension can be revoked. The revocation of suspension has some structure, some compliance point of view. So the people are confused that how they can revoke and what they will do with this company. So today we will discuss each and every point on journey of starting suspension to revival. We are extremely fortunate to have with us the most important and eminent speaker from Bombay Stock Exchange, Mr. Gopal Kishan Iyer, very old friend of mine. We call him Gopiji, and he is the person I respect for his knowledge and his experience in this. He is the head of listing compliance and legal regulatory in BSc. He is a fellow chartered accountant and has been the BSc for last 24 years, having expertise in listing, broker supervision, membership compliances, investor service, monitoring of compliance by listed companies, IPO and delisting process, and investor complaint against companies and brokers. Welcome, Gopiji, for today's program, and I hope.
Thank you, Pawanji.
With your vast experience, and not only the experience, but the knowledgeable experience, will help companies to understand, and they will realize that what are the consequences and how they can do. And various issues are there, various suggestions are there, which we have received from the investor that we will discuss, and hope the BSc will look into this and they will work out certain things. So after that, we have Anjali Agarwal. She is partner and head capital market corporate profession, having 20 years experience in the capital market transactions and various right issue, buyback, private placement, and various SEBI related issues and stock exchange related issues. I welcome Anjali. Then we have Manoj Kumar, partner head M&A insolvency and transaction advisory of corporate profession. He is a member of National M&A Council of ASSOCHAM, Insolvency Law Committee of CCI, and Company Law and Corporate Governance Committee of PSD. He's prolific speaker and he's writing various articles and quotes in newspaper and various magazines. Then we have a Charu Bakkar. She is ACS, Assistant Manager, Capital Market Service Corporate Profession, and she looks after the suspended companies, revival, and their other related aspects. Friends, as you are aware, this program is important because I told you the capital market is the stock exchange is a manufacturer of liquidity, and if the companies are there, then liquidity will be there. And always when liquidity is there, then the impact cost is less. Impact cost means where the liquidity is more, the cost of the buying and selling, the gap is less. That's called impact cost. That is less. So if the impact cost is less, then investor, if he's buying and selling, then he can anytime buy and sell. The difference is very less. All these things, if liquidity is disturbed, this is affecting. And this is affecting, and this is creating monopolistic situation of few scripts. So if the number of more shares are there, then investor has a choice. They can buy and they can do the transaction. So today we will understand that this concept of suspension, how, why, and how the revival can take place. So first I will invite Gopiji for this session. Then Anjali will discuss about, and then Charu will speak, and then Manoj will tell revival plan through restructuring, and then we will have a question. So over to you, Gopiji, for
Thank you. Oh, I hope I live up to my expectation. You have set the expectation so high. So I have a very short presentation. Am I audible to all?
Yes, yeah.
Okay. So I'll just share my short presentation on. Is it visible?
Yeah, it is visible.
Okay.
Just convert into the slide share mode.
It is in.
Yeah, go to this slide shares on the top. File, home, insert, design, transit, animation, and slide share.
Just a sec.
So just click on F5.
F5.
Yeah.
Vivek is this. Yeah. You go to on the top when home button is there, home, insert, design, transaction, animation, slideshow. So just click on slideshow.
Is my screen visible now?
Yeah, you can go ahead.
But I'm not able to see my presentation screen. How do I do that?
एक बार चेंज करके देखते हैं हमको दिखता है क्या चेंज्ड इस शेयरिंग को दिखा लेसन दिस मीन इज शेयरिंग
So do I start now?
Yeah.
Okay. So I'm taking you through this the latest the last circular which has been issued by SEBI in terms of the SOP for suspension and revocation of trading of securities, which is the circular which was issued on 22nd of January 2020. Now, if you see, there are a host of regulations, the non-compliance of which leads to levy of fines. But the number of regulations or the number of requirements which finally results into suspension are only 5, even though there are about 7 of them listed out here. 3 pertains to corporate governance provisions. So these are the 5 grounds on which the exchange would proceed to suspend the trading in the equity shares of the company. Now, it must be very clearly understood that suspension is not something which is desirable because the investor's interest is affected. But then that is the reason why the exchanges and SEBI, when they sat together in framing these SOPs at various points in time, we have taken into consideration the fact that there has to be a graded action against the companies for not complying with the listing regulations. But some of them have serious consequences because that is the benchmark or that is the basic information which is required by the investors to trade on the exchange. And hence, these substantial compliances have been considered for the purpose of suspension of trading. The first one being Regulation 17(1) relating to board composition, where the board, if the board composition is not as per the requirements of corporate governance where it is applicable, or the appointment of women director, and if the non-compliance continues for 2 consecutive quarters, then we would go ahead and suspend this. And there is a graded mechanism or graded process which we follow. It's not that it is very abrupt. There are adequate notices which are given to the companies before we suspend. The second one is on the constitution of the audit committee. If it is not in line with the provisions, then if such non-compliance continues for 2 consecutive quarters, it would result in suspension. The third one is non-submission of the corporate governance report itself for 2 consecutive quarters, which would result in suspension. Then
your presentation is not moving. Can you just see that this first page is coming?
Just a sec. Have you come to the second page? Are you able to see the second page?
No.
Just a sec. I'll just stop sharing. Share the screen.
This should be.
So this is the one. Okay, Windows shared.
So is it first screen which is visible or second screen, sir? With a white background.
Now first screen.
First is
Earlier it
visible.
was- Earlier it was second, yeah. Now it is first. Now
While
second. Now second, yes.
So,
Okay,
Now
so
third.
usually,
It is moving now.
so okay, fine. I'll just then. Is it full screen now?
No, not full screen, but it is first page. So you can go to second page, no problem. Directly you can go to second page.
Now, is it the second page is visible?
No, first page.
okay. So
I think then I will.
Yeah,
now
it is
second
visible.
play.
Yes,
think
now
I-
it is second page, yeah.
But
Okay.
is it clear enough?
Yeah, clear enough.
Yes. Yes, please.
Okay. I don't know why it is.
Because one number.
Okay, so Regulation 31 would be non-filing of the shareholding pattern for 2 consecutive quarters. Then Regulation 30 is submission of financial results for 2 consecutive quarters, and 34 for non-submission of the annual report. So basically, financial results is a very important information that is required by the market to factor in the price. I mean, for an efficient price discovery, you need financial results. And the shareholding pattern, of course, would tell the investors at what point in time, what is the holding of the promoters that is available. I mean, is the promoter continuing to hold what he was holding as on the last date, or he has disposed of, or are there any other encumbrances, or he has created certain encumbrances against the shares. Now, what has happened is, especially in relation to the shareholding pattern, SEBI, if you were to look at the changes in the shareholding, SEBI has now come up with the system-driven disclosures, which is for takeover regulations and for the insider trading regulations. So, effective from April 1 to 2022, the exchanges are disseminating based on the information that is received from the depository system on what would be the triggers, applicable triggers under the takeover regulations. If the promoter were to divest his shares or were to increase his holdings, then that would get automatically disseminated on the exchange on a real-time basis, rather than waiting for the promoters to get back to the exchange, make that submissions in paper form, because there is no direct linkage or there is no direct interface which is provided to the promoters or any third person from making their filings to the exchange. Obviously, because exchange will not be able to recognize if the person who's filing with the exchange is a promoter or any other third person. So that is why we have relied on the information that is available in the depository system. So it is an inter-MII exchange of information which puts out this information. And going forward, we are also contemplating, or we are trying to work out, even for this shareholding pattern, if we can work out a system driven disclosures wherein the companies may not at some point in time in future not required to file the shareholding pattern at all, because based on the information that is available in the depository system, the exchange would be able to display this information as is provided by the depositories. But there are certain challenges there which we are trying to iron out and trying to find a solution to that. So more and more, the exchanges are working on having system-driven disclosures if it is made available through any source which is a single source of truth. And from there, we would then go ahead and publish those information, and this would ease out the filings by the company. But till then, these are the five and the last one, of course, is the reconciliation of share capital audit report, which is one of the regulations, though it is doesn't form part of the LODR regulations. It could form part of the DNP regulations. But non-filing of this for 2 consecutive quarters is a trigger for suspension, but there is no fine levied for this particular non-compliance. And similarly, if we receive any notice of suspension from any other recognized stock exchange for any or all of the above grounds, then we would go ahead and suspend the trading. Now, you must also understand that under the provisions of SCRA and SCRR, Rule 19 very clearly provides that exchange can go ahead and suspend companies for non-compliance with listing regulations or listing requirements by giving notice in writing. So, which means under the law, exchange has powers to go beyond these regulations to penalize company by way of suspension. But currently but that would be only in extreme cases, very extreme cases where it is found that the trading in the securities of this company is not desirable, that we would go ahead and suspend those companies. But by and large, our suspension triggers are these clauses, and this is obviously based on a periodic review. And we carry out, how do we carry out? So we do the periodic review, which happens within a month of the last date of filing of the particular regulation. We do a review. This review is shared with the other exchanges, and we come to the common list. And then we also try to ensure that companies comply before those timelines, and then we would, so that it doesn't end up in companies getting suspended. Now, exchange also has proactively started sending out alerts before the due date of compliance, that this is a compliance which is coming up in future. Please ensure that you file it within the timelines. So this continues. 2 or 3 reminders are sent till the date of compliance, and then after the date of compliance also we do send it that there is now a non-compliance on this part. We are trying to automate this part now, that after the date of, because most of these are all XBRL filings also, we would be putting out in the listing center that you have missed out on a compliance for this particular not only for these triggers, but not these regulations, but all other regulations which are getting filed through the listing center. We are in the process of putting out an automated alert in the system itself, wherein you will get to know that you are non-compliant with certain regulations. The first one being on the time-based compliance, which would be whether you have submitted or not submitted. Then the second would be the substantial compliance on whether you have actually submitted what is required under that particular regulation and complied with the specific regulation. So that is in terms of the suspension triggers. So first you have the fines being levied if you don't file it in time, or there is non-compliance with respect to these requirements. And then further penal action as a graded action would be freezing the promoter's accounts. Now, initially under the 2015 circular, it was only restricted to the ISIN freezing, but in 2018, this was extended to all the Demat accounts for all the ISINs in the promoter and promoter group. But that particular requirement has now been diluted to say in the 2020 circular to provide for the freezing of only the promoter's account and not the promoter group account. But that freeze would continue till the fines are paid and the non-compliance is rectified. Now here I would like to emphasize that if a company is suspended for a particular reason, then it's not compliance with only that particular regulation that it would come out of suspension. Because at that point in time, at a point of revocation of suspension, the exchange would also see whether you are in compliance with other regulations. So it's not that once you are suspended, then you get suspended again for some other reason, because we keep sending notices to you about compliances or non-compliances with respect to other regulations. So we would want a complete compliance with respect to other regulations too before we revoke suspension of securities. Now, in this regard, what there are some developments that have taken place. In fact, internally also we've been discussing on this, and also with SEBI, that considering suspension and then continuation of this suspension for a very long period of time is not a desirable situation, because investors' interests are affected. So we have very clearly post April 2022, rather from January 2022, we have put in place one SOP that if a company gets suspended, then post suspension, we would be reaching out to the company and actually asking the company to get itself revoked within a period of 6 months. Otherwise, we would actually close out the case for delisting. So 6 months of suspension, immediately there will be a process of delisting which would trigger. So going forward, probably you will never find that companies remain suspended for 1 year, 2 years, 3 years. No. Post 6 months, immediately the process of delisting gets triggered. And if you don't complete it within the timelines, then companies would get compulsorily delisted, and then the consequences of delisting would apply. And as you all know, that once the company is delisted under the new delisting regulations of 2021, even the compliance officer, I mean the person who is in charge of ensuring compliance, also gets affected by the consequences of delisting under regulation 34. So it will be the whole time member, the promoters, and the companies promoted by these promoters all face consequences of delisting. And the promoters' Demat accounts get frozen till the time the fair value as may be put out by the exchange is not paid by these promoters. And not only that, for 10 years, they cannot be associated with the capital market. So these are very, very dire consequences if the company ultimately gets delisted from the exchange. So we are, as an exchange, very open to, and we are very, very keen that companies get their suspension revoked. And we would be, and going forward, you would also see that the exchange would be engaging with the companies on a very regular basis now on, and the follow-up will be going to be very proactive from the exchanges side also, to ensure that the companies, they seek revocation of suspension. All along what we have been finding, especially when we find cases where the companies are suspended, they would file couple of documents and then which is incomplete, and then they would take their own sweet time to complete the other formalities, which leads to a long delay, and then the investor's interest is affected. But that is not going to be what in future, followed in future. We'll see to it that there is a time-bound action plan for the companies. If you have to complete it within that timeline. It cannot be a situation that you put a foot in the door and just keep matters lingering. That is no more going to be the case forward, because 6 months is what exchange looks at. If you don't do it within that time period, then we should actually take consequential action of delisting this company. And obviously, we will be providing all the support that is required by the companies to ensure compliance, and there are practicing CS professionals who help these companies. You can always reach out to exchange for any sort of guidance, and we are there to help you out, because for us trading matters the most than suspension. So for us trading is what is required, and and suspended companies, they lend a very bad name to the exchange, because there's no point in having a company listed on the exchange which is not trading. So I would stop here, and I would take any questions that would you would want to throw at me, and I'm glad to answer those questions. Thanks.
Thank you, Gopiji. Thank you. You have given the complete SOP of how the suspension take place and what are the and there are various issues connecting to this. We will ask during the question answer session.
Yeah.
Anjali, you just given Anjali is giving Gopiji presentation on the side of companies and promoter, what they are facing and how things are. The object of this webinar is that those who are belong to the suspended companies, promoter and other things, they should realize that by keeping these company in the stock exchange drawer is not possible. You have to act. You have to do something. So either you clean this company, suspension, otherwise you will face consequences. So now, Anjali, over to you. Please tell us that what are the other aspects of this suspended company.
Good afternoon, friends. Am I audible?
Yes.
Yes, yes.
First of all, thank you, Gopi sir, for giving the overview of how the suspension happens. And because many companies remain in this confusion that even if we do the non-compliance for one particular quarter, we may be suspended by the exchange, but there are proper SOP circulars in place which determine or which govern the suspension or the next processes that may happen on any company because of non-compliances. So first of all, we need to understand as to what is a suspension. There are various types of suspensions. In my practical experience of all these years, I've realized that there are varied reasons for any company to get suspended. And likewise, even the solutions for those suspension, revocation, or the way forward are also equally varied. So when we talk about penal measures, there are two types of suspensions, majorly penal and procedural. When we talk about penal, as a penal measure, it can be a lapses of SEBI regulations, it can be non-payment of the listing fees or the penalties which have been imposed by the company. Now, SEBI regulations, non-compliances are also varied types. Listing agreement, listing regulations, non-compliances that have been taken very well by Gopi sir. If there is a capital mismatch, meaning thereby that the company made some allotment in the past, say a preferential allotment or a rights issue, but the same has not been listed on the stock exchanges, that can also be a reason for the suspension of the company. Then there is a distinctive number mismatch. As per the RTA data, the distinctive numbers are something else. As per the company's records, it is something else. As per the exchanges records, it is something else. That also may be one of the reasons for suspension. Then family disputes. If a company has been promoted by, say, two brothers, and there happens a dispute between them, and there is nobody to do the compliances, nobody is ready to take the responsibility of doing the compliances, the suspension is about to happen. Then MPS non-compliance. In the past, we have seen that there were many companies which used to be referred to BIFA, and as a result of, and in most of the cases, in most of the BIFA cases, the promoter holding used to breach the 75% threshold. So if there has been an MPS non-compliance and the company fails to comply with the said fails to comply with the 75-25 norm, then a suspension may happen. As Gopi sir said, because of the non-compliances of DNP regulations, also suspensions happen. Then, when we talk about non-payment of listing fees, scarcity of funds is a major concern with the company, that businesses of the companies have stopped for whatever reasons, and there is a fund shortage. Company does not have the money to pay the listing fee, and it is again goes to the suspended basket. Then reference to BIFO. In the past, whenever any company used to go to BIFO and it was not able to comply with the requirements, it used to be suspended from trading. Surveillance measures also, many a times companies are suspended because of surveillance measures. Say a preferential allotment has been done in the past and the exchange or SEBI finds out that there were certain lapses of the DIP guidelines or ICDR regulations, or certain circulation of funds is noticed, then the trading in the shares of the company may be suspended. Or there are trading or pricing irregularities in the company. As Sir said, it has to be in a graded manner. So we have seen that we see that there are many some companies which are suspended because of the initiation of graded surveillance mechanism in the company. Now the next type of suspension is, which is not a serious one, wherein we say that it is on account of corporate actions, procedural reasons. In case there has been a merger, demerger, or capital reduction in the company, and a record date has been fixed, the company is suspended for a limited period of time. It is called procedural reason. And in case any company has been referred to the insolvency process, then for the insolvency companies, IBC companies, again the company is suspended. Now, with regard to the provisions which govern a suspended company, I'll ask my colleague Charu to take up the next slides. Charu, over to you.
Thank you so much, ma'am. So taking the deliberations forward, as explained by ma'am, that suspension can be done for various reasons. The provisions which govern a suspension in a company are governs from the Security Contract Regulation Act and the SCRR rules, and there is a SEBI General Order which came in July 2015, and the SOP circulars which Gopi sir has already explained earlier, which governs the suspension in the companies. So how a company gets suspended on an exchange? Taking it forward that there is a due date for the compliances of various by which the companies has to make the compliance good, and they have not been done. Then within 30 days of that, the stock exchanges issues notices for the non-compliances and levy a fine. In furtherance to that, within 15 days, either the company makes good the compliance or make the payment of fine, or either can proceed for the waiver of the same. But in case where the companies fail to do so, the consequences for the same proceeds further, where the companies, the trading gets suspended. So, if we see, as explained by Pavan sir, in the starting itself, on BSE there are approx 800 companies which are suspended presently, and at NSE there are 100 companies. And if we exclude IBC companies and RE share companies, then also approximately 500 companies are there which are suspended on BSE, and nearly 70 to 80 companies which are suspended on NSE. So I'll hand over from here to Anjali ma'am.
So thank you, Charu. So as explained by Charu, if we talk about a total of 4,000 or 5,000 listed companies, approximately 10% of them are suspended on the stock exchanges. And suspension, as Gopi sir also said and Pavan sir also said, is not a desirable mode at all. It has severe repercussions on the promoters, it has severe repercussions on the company per se, and also on the general public shareholders. If we talk about the repercussions it has on the promoters and promoter group companies, First of all, free promoters' Demat accounts are frozen. Gopi sir has also mentioned that as per the January 2020 SOP circular, promoter group Demat account is not frozen. Then promoters, because of the freeze, are not in a position to transfer their shares or pledge their shares. They cannot even raise any further funds from the public. It gives a negative image to the promoters, and of course their credibility also gets affected, and which in turn affects their bank funding boards, and the further funding channels get choked. Now, when we talk about the listed company, penalties, so in any case, every day there are penalties to the range of 1,000 per day to 5,000 per day, and in a few cases even 10,000 for second instance. So these are per day basis penalties. So these keep on increasing on a daily basis. Trading in all the categories that are there, trading categories, Z is the worst category, which we say in general common parlance. Now the trading gets transferred, the company gets transferred to the Z category. There will not be any trading in the shares of the company, so no liquidity, no market capitalization. The company is stuck. The way promoters' credibility was affected, likewise, companies' credibility is also affected in the suspended companies, and the bank funding channels get choked. They cannot raise any further funds from the public, and obviously these all give a negative image to the company. On the normal retail public shareholders of the company, the value of the stock gets diminished over a period of time. The marketability gets eloped, and no exit option available to those shareholders. They are the worst sufferers of any suspension action that happens. So now, what are the options available to me as a suspended company? I have to decide whether I want to remain a listed company or I do not want to remain a listed company. Under both the situations, I have to go ahead with revocation of suspension. If I want to remain a listed company, the best is to complete the revocation formalities and continue as a listed company. And if I do not want to remain within the listed regime, then I can go ahead with suspension revocation and proceed with voluntary delisting. When we talk about revocation of suspension, there is a procedure which has been laid down by the exchanges. This is the procedure which is followed by the Bombay Stock Exchange. So companies have to comply with all the requirements of listing regulations for last 4 consecutive quarters. One of the important requirements is that there should not be any mismatch on the paid up and the listed capital of the company. There should not be any SEBI order debarring the company or the promoters. Then there should not be any exchange, no outstanding exchange dues should be there. No penalty, no investor complaints should be there on the score. Pending investor complaints, a uniform listing agreement is needed to be entered into. There is a site called Watch Out Investor site. On that site, there should not be any adverse comments against the company or the promoters. Company should not be a vanishing company. Exchange will conduct a site visit at the registered office of the company. Ever since Corona, this site visit is being undertaken on an e-mode. Otherwise, earlier exchange officials used to come to the registered office. Now it is being conducted in an e-way. Then you have to sign the agreement with both the depositories. There are some companies which have even today have the agreement only with either NSDL or CDSL. But for revocation of suspension, this will not suffice. We need to have the agreement with both the companies. And the requisite fees is needed to be paid, be it annual listing fee or revocation fee or reinstatement fee. So as I explained that this is just a crux of it, comply with all the pending compliances, apply for in-principle approval to the stock exchange. Post in-principle approval, need to file the final application along with payment of the reinstatement fee. The exchanges issue a notice for revocation, and then the defreezing of the promoter's account happens. as Gopi sir also said, if the suspension is not, if the revocation is not proceeded with within 6 months, the exchanges as per the SCRR rules and the delisting regulations and the SOP circular have the power to proceed with compulsory delisting. And in times to come, this may become shall and may will be the ultimate fate of all the suspended companies which remain suspended for more than 6 months. So what is the impact of compulsory delisting? Now, this is driven by the SEBI delisting regulations of 2021. So the impact is on the promoter, on the listed company per se, and the promoters, promoter group, and full-time director, and also on the persons who are responsible for making the compliances of the securities laws. So promoter, these definitions have been defined in SEBI ICDR regulations. Promoter is the person who directly or indirectly controls the affairs of the company, or on whose advice or directions or instructions the board is accustomed to act. So anybody, whether appearing in the promoters list or not, but if somebody is the person on whose instructions the board acts, would also fall within this ambit, and he may have to face the consequences of compulsory delisting. Then promoter group, it includes the promoters, then immediate relative of the promoters, any holding or subsidiary company of the promoter, any entity in which more than 20% shareholding is held by a body corporate or vice versa, and any HUF or firm where the promoters or the relatives own 20% or more. So this promoter group definition is a very, very wide definition and not to be taken lightly at all. Promoters, I promoted a company, but then by virtue of the definition of promoter, my entire family, virtually my entire family becomes a promoter group, or any entity wherein I am holding more than 20% is also my promoter group. So that's a very wide definition. Full-time directors, that is the directors who are in full-time employment of the company, and persons who are responsible for ensuring compliance can be the company secretary, can be the compliance officer, or even the CFO of the company. So these persons are debarred from accessing capital markets for a period of 10 years. There have been cases wherein a company was delisted, compulsorily delisted, and now a group company of its, which was a very small company at the time of company A's delisting, but now it wants to come out with an IPO. Now it is being debarred for the reason that you were forming a part of the promoter group of the company which has been delisted. Likewise, these persons, promoter group, full-time directors, or persons responsible for making the compliances are ineligible to become the directors of any listed company till the time they provide exit option to the shareholders. So these are very severe repercussions which are needed to be kept in mind while deciding the route forward for a suspension, for a revocation. Along with the above, the stock exchange may even file a prosecution. The promoters have to pay the exit price to the public shareholders. This exit price is determined by the exchange at the time of compulsory delisting notice, and the exchange may even initiate binding up proceedings against the company. Recently, and that's the object, the basic idea where from we thought of having this webinar, recently stock exchanges have issued show cause notices for compulsory delisting of the companies which have remained suspended for more than 6 months. So once this show cause notice has been issued, then what is the option available to the company? So first of all, the company should make a representation to the exchange for stopping this compulsory delisting. Simultaneously, it should complete all the pending compliances. And as Charu said, that it should either make the payment of the fines or apply for waivers thereof. And once either the payment is made or waiver is approved, then filing of revocation application with SEBI. And once the in-principle approval is received, then payment of reinstatement fee and ultimately revocation of suspension. Now, the next question that comes to us many a times. Revocation kara ke what will we do? मेरे पास पैसे नहीं है, what do I do? I don't want to remain a listed company, what do I do? I have many other group companies which are getting affected because of this suspension. How to get out of this situation? So the remedies that are available to a suspended company or post revocation. In fact, there are some companies, there are some people who are willing to invest even in a suspended company. They are willing to fund the funding requirements of a suspended company. So the options available are revival, restructuring, or exit. Revival, I've already taken. Exit, if you revoke your suspension and then get voluntarily delisted. And restructuring can be either, I'll ask my colleague Manoj to take up the restructuring portion of it with regard to mergers or organic and inorganic matters. Manoj, over to you.
Anjali, before this,
Yeah.
so friends, the Anjali has told the entire thing, that what are the consequences of suspension and then delisting. So you can understand that these are the things which are very, very harsh. It is just like a body which is in coma and it will die after some time. So you have to do the kriya karam of this particular body in any way. Now the question is, either I can keep this body or I can go to the hospital and give the proper treatment. You cannot keep that in your home just like this. So the point is that suspension, SEBI and stock exchange are very clear that they are putting all restriction, 10 years debarment, freezing of the entire account of everybody. Earlier it was connected to that particular script. Now they are saying the entire account is defreeze. It is not only the promoter, but promoter group companies promoted by the group company of these promoters. So you can, and the whole time director and the person who is doing compliance. So you can understand the area is wide, and this area is wide is not only restricting to the few entities. It can anybody. An innocent person can also come into this. Like I am holding 20% shares. Somebody has invested 20% share in my company, and I'm running this company properly, and suddenly you are debarred. And so because you are holding 20% shares in my company, so my company will also come into this category. So the consequences and repercussions are serious. So now we have to understand that how we can do this. So one point Anjali has told that you have to revive. So the revival process, we will discuss this. But the question is, we have 2-3 options. One option is that we do the restructuring of this company. Like restructuring means that we have various companies in our group. So first, either we can make this company good and start doing business in this, or we have various other companies. We have various other companies in the group. These companies we can merge and we can do this. So Manoj, please tell us that how the restructuring can help, and what are the options, and what are the problems you are facing when you do the restructuring merger in the group companies, and what are the various other organic and inorganic methods. Over to you.
Thank you very much, sir. As Anjali ma'am has already explained in detail, what are the consequences of a company continuing to be suspended for long. And Gopi sir has also said that ultimately it is not a desirable situation that a company remains suspended for long. So ultimate thing is they will be delisted, and consequence of delisting is very harsh, as explained in detail by everyone. So we have to see what is the reason a company is suspended. We all know that listing has a certain inherent value. If a company is listed, it gets much better value in the market. Investor has confidence on it because of the liquidity of the shares. Then another thing is the lenders also have more confidence on company which is listed, because they get continuous information about the results of the company on quarterly basis. There is a disclosure relating to shareholding, who are interested in this company, who are selling or who is buying the shares of the company. Then there is a better corporate governance, which is ensured through independent directors, audit committee, and all that. So these things create very positive atmosphere about the company, and it leads to better valuation, ease of raising funds either in the form of equity or debt. And it also gives opportunity for the promoters of the company or the holder of shares to raise funds by pledging of shares or many other ways. Then the shares of a listed company can also be used as a currency for inorganic growth through swap of shares. By say transferring certain shares, you can buy business and grow. So these are the advantages of having a listing in a company, and that's why many of the companies, ultimately all the companies which are getting matured, would like to get listed on stock exchange. Considering all these benefits, if the company is suspended and is not getting revived, there must be certain deep issue. So we have to understand those issues, and then based on that we have to find out solutions. So let's say a company which is financially stressed and there is no money to pay the listing fee, and there is no business. In that case, obviously the solution cannot be simply to pay the suspension revocation fee, because there is no business, there is no scope for growth. So ultimately, in this case, the promoter would not like to put further money on the good money on bad money. So in that case, I think the solution could be finding some partner or a strategic investor who can come into the company and put some business and get ready to finance. So that can be one of the solutions. If the company is if there is another issue, let's say if there is a dispute among the promoters, and that's why nobody is taking care of the company, in that case, obviously there has to be some family settlement arrangement in which this company may be handed over to one group, and then that group can put their own business into it and grow it further. There may be a situation where there are past losses, many substantial losses which has wiped out the capital of the company. In that case, we can find out some solution like reduction of capital. The losses may be knocked off with the capital, so that the company's book value and the fair value, market value, comes near to each other, and then it is easier to find investor. Because if there, let's say, a company having losses and not having substantial business is continuing to be traded at, let's say, 10 rupees, or we cannot allot share even just after suspension revocation at a price lower than the face value of the company. So it is obvious that in that case, no investor would put the money into the company for revival. In such a circumstance, first step would be to reduce the capital and close the fair value and the face value near to each other, so that investor can be interested to put money into the company. Then there may be situation where there is a mismatch of capital. Certain capital is not listed. In such cases also, reduction of capital can be one of the way. The company can enter into some scheme of arrangement to reduce those unlisted capital, repay the money, if any, which has come from investors, which is not yet listed. So we have carried such kind of restructuring, and that had helped the company for further raising of funds. Because if there is one lot of shares which are not listed, further raising of fund becomes very difficult. So all those solutions can be thought of, and we have successfully done such kind of internal reorganization in many of the cases. If the company is cleaned up and the balance sheet structure is strengthened, then obviously any of the promoter would be interested to put their business into it, and then so the merger can be one of the way, or it may be a slump sale of the group company's business into the company. So we have to those solutions can be found out after cleaning of the company, making it better. And there are, as Angli was saying, there are many persons who are interested to put money for revival of such type of companies, considering long-term growth benefits. They want to unlock their business value. So consolidation of those businesses into the company can be one of the way. Obviously, we have to take care of the takeover related law, takeover offer requirements, or approvals requirements with respect to mergers and acquisitions. So those things need to be complied with, and these can be very good solutions. It is a win-win for the company as well as their investors. whenever the investors, whenever the company is stuck under suspension, they will not get any advantage. They cannot trade into their shares. But even if let's say there is a past losses and which is due to which share capital is reduced, lower number of shares may be there, but that would start trading. That would at least unlock the value of those shares. So I think these are the broader aspects, and we can obviously it has to be on case-to-case basis. We have to find out the solutions. I think we can discuss further based on the Q&A, if any. Thank you very much.
Okay, thank you, Manoj. Thank you very much. We will discuss this issue during the question answer because there are so many new aspects. Now, Anjali has talked about the revival. You have talked about the restructuring. Then another third option is exit. Suppose the company is, you are not able to manage the company, then you can sell this company also through legal route by open offer. There are so many buyers they can take. So it is better to alienate this company from your group. So you should not face consequences. So thank you all the speakers. Now time for question answer.
I'll Mohanji, 1 minute. I'll just like to cover a couple of more things.
Yeah.
One is that where you are where the exchange is levying fines on the companies, you can approach the exchange for waiver of those fines. We have already put out the carve-out policy on the website at which instances would fall under waiver. And not only that, what we've also done is post-April of 2022, if there is a non-compliance on both the exchanges, then we have put out the list of companies which need to appraise one of the exchanges. Okay, it is not that you apply to both the exchanges, it is only one exchange which would look into the matter and dispose of that matter, and the other exchange will piggyback on the decision of that so that time is saved, the resources are saved, because otherwise both the exchanges may end up having different decisions. So this will be one decision in one matter, and so ease out the compliances for companies. This is something which we have worked out with SEBI. The second thing is that I would urge all the company secretary professionals, all the company, to please go back and look at the classification of promoter and promoter group, because people have very loosely defined promoter and promoter group, and exchanges in the shareholding pattern have provided the facility to indicate whether the person is a promoter or a promoter group. The reason why we are saying this is, as per the 2020 circular, the freezing would apply to the promoter group or a promoter entity, not to the promoter group. Now, many of the persons in many of the companies, we have found that all have been defined as promoters. We are okay with it, but then there are consequences. The promoters who have been holding shares for long, probably because of their family relationship, holding 100 shares, not knowing that they are promoters, their Demat accounts get frozen because they are shown as promoters. Okay, once the suspension happens, it is very difficult to even do a promoter reclassification. In fact, you should go back and tell all those persons, please have a relook at the promoter group entities. If they don't fall within that category, you must carry out the promoter reclassification as per regulation 31A. Now, this is not applicable for suspended companies or if there is fine outstanding. These are two of the main requirements. But it would ease out the pains of a lot of people who even don't know they have been classified as promoter in the company, because probably they have been holding shares since age-old times when they used to fill out the promoter quota forms and they got 100 shares and they have been shown as promoter. I mean, that's something which is a pain point for such investors, who don't know that they've been classified as promoter, or even within the family. You may be uncle's son or whatever, because within the family you would have applied and they have been shown as promoters. Today we are having situations where, because of holding of such 100 shares, 50 shares, those promoters have been debarred. Okay, because they've been shown as promoters. Now post delisting, such promoters cannot enter the market because they have been shown as promoters. There is no process for reclassification post delisting. So we are facing such issues. So please, you must advise all your clients or listed companies, or if they're practicing company secretaries or company secretaries out here, please check the promoter list which is shown under the shareholding pattern. Ensure that it is correctly classified. Then the last thing is, of course, the penalties. See, the penalties that are levied, or rather the fines which are levied under the circulars, have actually not turned out to be a deterrent. So you must be mindful that there are discussions for substantially increasing these penalties or these fines, because it's not, one thing you must understand is that it's not that we want to levy fine and earn money out of it, because entire money would go to IPF. It doesn't accrue to the exchange at all. But it should act as a deterrent to companies. At least the fines, if I say 20,000 per day, for example, it should hit somebody, right? Somebody should be very serious enough that it is better to comply with the requirements than to face a penalty or a fine of 20,000. So these are some of the points which I thought I should bring to your your knowledge, so that
one point that suspended company can go for reclassification.
Suspended companies cannot go in for reclassification because 31A requires, there are two conditions. One, it should not be a suspended company. Two, there should be no outstanding fines, penalties, or fees to the exchange and SEBI. So these are two requirements. So a suspended company will not be able to go for reclassification.
Okay. And then why the BSC, NSC fines are different? Revocation of suspension fees.
See, revocation, both exchanges have different models. Okay, both revenue models for both the exchanges are different. So we will not be able to compare on those terms.
Okay. So I think you have added the correct point now. Now there are some people are asking various questions. What is the logic of expending the entire promoter and promoter group or promoted by the company? Is it not a hardship to the people? Because we have so many cases where family is divided. They started business long back together. Now they are separate. They have done the settlement. Okay. And they are facing this type of problem because they come under this strict definition. Is there any solution for this? You have to unmute yourself. Unmute. Gopiji, you have to unmute.
Okay, sorry. So the only way out is that you need to go for a promoter reclassification. We've been advising many of the companies. That's why I told you, many of these companies post suspension, when they see that their Demat accounts have been frozen, that they come back running to the exchange saying that we are never in contact with them, or we have got separate businesses, or we have separated long time back, but they continue to be shown as promoters. Best thing would be you enter into a deed of separation with them, a legal document, comply with the provision. There are certain conditions which are prescribed under 31A. Ensure that are there as part of the separation agreement, and then file it with the exchange with a reclassification application as is given. We would allow a reclassification.
Okay. There is one problem that one person is asking. I'm a shareholder of a suspended company because of non-compliance by the promoter and consequent suspension. The general public, general shareholder are the sufferer. Any solution to this situation? You have to unmute. I think unmute yourself, Gopal.
Every time I'm unmuting. Okay. Currently, there is no provision for any compensation or any relief that would be available. One thing that I can say is that when a company is suspended from trading, the exchange allows trading as per the SOP circular for 6 months. Okay, so the trading happens on a weekly basis. On every Monday, there is a trading available. So if the investors want to get out on that day, they can get out. If there is a buyer available, they should then exit this company for 6 months. But if they choose to remain listed, or even for suspension, before suspension, there is a 1 month notice which is put out. So it would be desirable, I mean, if the investor does not want to, I mean, if the investor is now clearly aware that there is going to be a suspension, not clearly knowing whether this suspension will continue or whether the company will come back and revoke the suspension. So that is, see, this is a risky investment. This is a call which the investors will have to take on whether they would want to remain listed with this company, I mean, stay invested in this company, or exit within that 1 month period, or during the 6 month period when the weekly trading is allowed. So that is a choice to the investor that is available. But beyond that, there is no protection available. Even when the company is compulsorily delisted, if the fair value is positive, then there is an obligation on the promoter to ensure that that fair value is paid to the investor. But if it is negative, he loses everything. He'd lose everything.
Okay.
Sir, can we give a suggestion to SEBI in such cases that only the promoters are debarred from trading in the shares of the company, but public trading may continue? Because, I mean, what this person is saying is the public is the sufferer. So if
Now
we can,
tell me, okay, my only counter to that is there is no financial information. Okay, it is whether the shares should quote at 10 rupees, 1000 rupees, 50 rupees, that is not known. So on what basis will the value? There is no compliance, right? So if we believe that the price of a security factors in the financials of the company, then how do we allow trading? There has to be information in the market for a price discovery, right?
right, got it.
So that is the reason we would not allow, because see, one way of looking at it is that the investor is saying that how do we exit these companies? But you should also look at the other side. How do we allow gullible investors not to enter into such script? Because I don't know, because in this 130 crore, we have seen so many schemes in India running where people get caught with these scripts, right? And there are enough number of people who are going to, fool these investors into getting into the script. So it's better that if I have stayed invested, at least let it stop there. Let it not go beyond that. Let me not extend it to some person not unknowingly getting into that script.
Right, agreed.
Gopiji, my grandmother is appearing in the promoter group of suspended company, which she is 86 years old.
Yeah.
And they're undergoing IBC proceedings.
Okay.
Because she is an IBC. Her Demat account is frozen. She wants to give her shares to her heirs, but it is not able to do so. She was not involved in any decision making of the company since long.
See, till the time the final outcome of this IBC proceedings, once this, if this company, see, under IBC, either somebody takes over or there would be a liquidation. So if the court orders for liquidation, that could be a ground for you to approach the exchange for defreezing of the shares.
Okay. Can a company announce a split when the shares of companies are suspended on the exchange?
They can do that, but the issue is, they can do that. That should not be an issue. We don't allow any corporate action to take place, or we don't service the company if there are dues of the exchange which are pending.
Okay, but ultimately they have to come to you.
Yes, they have to come to the exchange.
No, if I have done the suppose I have done the split, that is my intention, but ultimately I have to come to the exchange to inform, and then shares will be
without fixing a record. Without fixing a record date, you will not be able to do a split. No?
Okay. Gopiji, one interesting question has come. A person incorporated many companies, both listed and unlisted, in in say 2000, there was a separate settlement in which his son received the business. A younger son who was not involved in his father's business, because when his father started business, he was minor. And after that, they have settled and they have given the business and there's a settlement deed. Now he's running the business and they were planning to come out with IPO. Now when they came out with planning to come out with IPO, then they came to know that their company is suspended and they have not received any notice because the address was not updated, because it's a old address where the company suspension notice and other thing has gone. What is the remedy to this company where the family settlement deed is there, which you have just now told, and their name is coming as the promoter group company, but this company was alienated from the main group? What is the solution for this?
Other than 31A reclassification, nothing is possible. For a suspended company, all these routes gets closed.
But if he proved that, suppose this is not a reclassification is not possible, but including his name by the in the delisting, can he challenge this to the stock exchange?
Increasing, but no, I didn't get a question. What is that? What will you challenge in the court?
Not court. Suppose the stock exchange has included that company's name also in the promoter group, which
one thing. Exchange does not include. It's all filings under 31, right?
Yeah.
Exchange does not classify anybody as a promoter or a promoter group.
Okay, but it is right that their name was in the promoter group, but later on there was a family settlement and they removed the company, the business from that group, because that is a settlement deed has taken place. But his name was coming and they have not removed that name. They have not done reclassification. So
optically, see, the issue is optically when a company is suspended on the exchange, and if we allow some of the promoters or the promoter groups to get out, it will not look optically correct from the investor's angle. See, when I'm talking from the exchange side, you must understand that my prime this thing is to see that investors don't question me as to why did we allow that person to get out, because he is then free to trade, his Demat account get unfreezed, whatever, all those things will happen. And the 2015 general order of SEBI, which does not allow such even promoter group the entities to raise capital, all these questions would then be raised on the exchange. So that is the reason why in a suspended status, exchange does not allow any such restructurings.
Okay. When issue size is less than 25 crore, or in case of right issue less than 50 crore, company is 1%. Why it is required letter? No, this is something different. I'm not asking some different question. Can 6 months from suspension be extended for delisting in any case?
See, 6 months is a time which we have set so that companies are very serious enough to complete it within the 6 months period. See, because if you see, the suspension is the recent 2 quarters, right? The recent 2 quarters, consecutive quarters, this one gets triggered as a suspension. And suspension is also not very immediate. You have the promoter freezing, you have the fines, and then you have the promoter freezing, then you have notice to the company to complete within 1 month, and then the suspension takes place. So, and then there is 6 months also. So these are not very onerous compliances that that is put out for the companies to comply. So 6 months is fair enough time for a company to comply. And then we are saying another 6 months within which I will do a delisting. So, but during that period also, I am following the process by issuing a show cause notice to the company why I should not go for delisting. So even that time is there. So probably you can take another 3 months within that 6 months, because I need to then place that matter before I need to issue public notices. I need to place the matter before delisting committee. So effectively, there is about 9 months time for the companies to comply, and I don't see any reason when a company can comply on a quarterly basis. Why should for a non-compliance it should take more than 9 months to comply?
Now there are 4 stock exchanges in India at present: BSE, NSE, MCX, and then Calcutta Stock Exchange, which are recognized till now. So how the arrangement you have done that you will get the information of Calcutta Stock Exchange or MCN and NSE? Is there any mechanism that you are getting information of each other?
No, there is no mechanism for Calcutta Stock Exchange companies. If that company is trading on my exchange, I would ask the company to list on my exchange so that I can enforce the listing regulations. But there is no information that we would get from Calcutta Stock Exchange on the listing compliance. But if it is listed on National Stock Exchange, and if I were to permit trading, I would know that they are complying with that national level exchange. And generally, if it is for MSCI, I don't think we would have any company which is listed there but could be traded on my exchange. So I would, in all probabilities, either it is not listed on my exchange and not traded on my exchange, or it is dually listed on BSE as well as MSCI.
Can the aggrieved companies entitled to dispute or challenge the notice of suspension or any remedy available?
Yes, you can appeal in SAT. That is clearly provided under SCRA. I think 22A or 21A. I'm not 22A. I think. Oh. So it can be challenged in SAT.
If company is in a process of revoke and in the process to comply with the regulation, in another side, if 6 months would be left, then in that case, also company would be delisted by exchange after 6 months. He's saying that I'm putting the revival process and that is going on, and my 6 months has passed. Can you do the delisting, or you will consider that revival process is
revival process? See, we would see, like I told you, the first 6 months itself, post suspension, we still have the 6 months time to wherein we engage with these companies to understand what is the reason why this non-compliance is not getting rectified. The company would approach the exchange at that point in time. So we would take into consideration all of these, but very clearly, we don't know when the restructuring would take place. That is beyond the control. So unless there is a clear forward path on what is going to happen, it would be difficult for us to consider timelines beyond the 6 months period.
Okay. One person is asking, I know, because if you see the BSE side, you will find so many companies, those who are suspended since long, 10 years, 15 years back, say 2005, 2007, 2015, and revoked recently as per the regulation. If the company not revoked in 6 months, then compulsory delisting, but have not happened to the company. So they are saying, why so many companies are suspended long back, and still they are not delisted?
In 2018, we had done a large delisting. A large number of companies were delisted, which went back to SAT, and they got reinstated back into the exchange. Now, some of those decisions came in 2019, and after that, there was COVID. So these companies, when they said that we would want to reinstate, 20 and 21 was the time when they said, we have been affected by COVID, so don't pressurize us to complete it so far. So we gave them that time. But then since December of 2020, we have started issuing show cause notices and to clean up all these old companies. So currently, if we have already issued to close to 383 companies the notice for compulsory delisting. So all this cleanup we have already taken up now. I mean, if you see, very frequently you will be seeing our ads in the newspaper for initial public notice for delisting. So all those will come up now because we don't, and some of these companies are also suspended for penal reasons, surveillance reasons, or some of them are CIRP companies. Because of the moratorium, I cannot proceed further. So we would await a decision of the NCLT in these matters.
Gopalji, I saw the Bombay Stock Exchange website. There's a suspended list, and their company's name was suspended in 2001, 2, 3, 4, 5. Still, they are not delisted. That time there was no CRP process, and
Right.
so why? What is the reason? Are these companies complying all the requirement, or still they are not delisted?
See, SEBI, when some of these companies would have complied, and as per SEBI SOP for suspension of company on account of non-payment of listing fees, SEBI has not given us the powers to delist such companies where only the listing fees is pending, but their companies complying with other requirements, which we would want to take up with SEBI, that there is no point in keeping any company in coma. So you should allow us to even delist those companies. Secondly, I told you about these companies which had approached SAT, and then SAT had remanded all those back to the exchange to give a fresh hearing and a fresh show cause notice. So that is the reason why we have already taken up about 383 companies for delisting, and many of them have actually come back and shown interest in reviving. And in fact, we have a committee which is pre-delisting committee, which would look into the representations of these companies on and look at what are their future plans. I mean, strict timelines are monitored on whether these companies are actually serious enough in compliance and getting. So probably by this year end, this entire list will be wiped out. The old companies will all either go into compulsory, because this is something which was taken note of by the delisting company also. So either they get into the revoke mode or they get it delisted.
There is an investor is asking one question: how individual can approach the exchange or SEBI for getting their investment back after suspension or delisting due to non-compliance by promoter or company management? Is there any provision, protection given to the general shareholder?
See, for a shareholder, as I told you, suspended companies, you have this 1 month window when we give advance intimation for suspension. So that's the time when he should get out of that stock, divest that stock, or within the 6 months period when he should divest his stock during the weekly trading period. And for suspension, there is no, see, very clearly, this is a stock investment in equity shares is a very risky investment. Okay. There is no protection, though exchange and SEBI, they do try to have mechanisms to have, safety of this trading place. There is no guarantee or that, exchange or SEBI will make good those investments. Ultimately, that is a decision of the investor whether to stay invested in that scrip or divest that scrip. There is a provision under the delisting regulations as once the fair value is positive, there is an obligation on the promoters to make good that money to the investor. But currently, there is no mechanism for enforcement of that, except to the extent that such promoters cannot enter the capital market till such time they make good that amount to the investors. So these are the current provisions which are available.
There are so many companies which are showing as a suspended. I think their ISIN number is there, or there is a RE. What is the full form of RE, and Anjali?
It's rights entitlement. These companies came out with rights issues.
Their name is coming in suspended list. I think BSE should clean up that RE issue.
Yeah. I think that we'll take it up. Yep.
Yeah. Okay. Does BSE publish list of suspended entity? How many such entity and market cap based on the last traded price? Where we can get the full information on this?
See, I had actually put into one of the question and answers. I've already pasted that link. It is there on the corporate section. You will find it under compliance and other info. So you will find a list of suspended companies.
Okay. Whether stock exchange has power to waive certain penalties or listing fees and give additional time to make the things good?
See, we have powers to waive the fines, except that it should fall it should fall within the carve-out policy that is already put out by the exchange. So if it falls within that, then exchange can definitely grant waivers. Listing fees, we don't grant any waivers for listing fees, because that is a bread and butter of exchange.
Okay. How the company received penalty notice in August 21? We made a representation of waiver before the exchange. However, till now, there is no response revert from the exchange side. We have been sending repeated reminder emails. Now I'm receiving emails that the company may be suspended.
You can send it to me. I've given 3 numbers. Okay, in that question and answer, I've given 3 numbers. You can send a WhatsApp message to all the 3. We will take care of that.
Okay. Gopalji, how the upon
in fact, what we are trying to do, even for revocation of suspension, what we have put in place since June 2022, we have created an interface in the listing center itself. So all requests would have to come through the listing center itself, and we would have a tracking through that on how many days it is pending, with whom it is pending and all, instead of sending all these requests through emails, which was previously being done. Even for the waiver request, we are going to put in the same mechanism, so that companies don't have to face this issue of repeatedly asking exchange or not receiving any response from this exchange. So we will have that also in the listing center, which should ease out the pains of the companies on this. But otherwise, I have given 3 cell numbers: my number, Ashok, and Netra's number. I suppose that Q&A answers which I've already given is available to you. So that numbers, you can send a WhatsApp message. We'll take care of that.
Okay. Gopi, upon revocation, how is the first day price computed?
The rule is, if there is no pricing history for 1 year, then the book value or the face value of the stock is put as the base price for the pre-open session. Okay.
Okay.
But if there is a trading history, where there is a price which is established during the last 1 year, then that price is taken as the benchmark price for next day's trading.
Okay. Gopini, 1 and 2 promoter group are holding shares in physical. Will the exchange proceed with revocation?
No.
And if
LODR regulation requires that promoter holding should be in Demat form. So we will ensure that that is done.
So,
as far as I understand, the revocation applications are processed, but the trading takes place in T2T. They're not transferred to X group or any other better group. They are shifted to T2T.
I think, So that was a reason. Correct. You're correct. So the reason why we did that was because if the promoters don't proceed with dematerialization, why should the investors suffer for that?
Right.
Because even in the normal scenario also, it doesn't get suspended. So we would allow trading. Sorry, I stand corrected on that. We would allow trading because investors' interests are affected, and because of some non-compliance by the promoter, we don't want him to lose out on that opportunity.
Gopalji, there are some companies, their shares are in physical and they don't have a PAN number.
PAN number?
Yeah.
No. What is the question? I didn't understand the question.
Our company is not in possession of PAN number of few of the promoter group. How to proceed with revocation?
See, then see, I think there is also a thought process, and if these numbers are very small in numbers, see, today there is a requirement that if you want to go in for a reclassification, see, okay, currently what we are following, I'll tell you, where this is not there, but the company wants to go in for revocation of suspension. The mechanism that we have allowed companies is that you shall ensure that RTA will not transfer the shares of these promoters whose PANs is not available. They will be frozen as and when they come for demat or transfer of these shares. You shall ensure that you will first provide the PAN to the exchange before carrying out the demat request of these promoters. Secondly, you shall also issue letters to these promoters and also issue a public advertisement in the newspaper trying to reach out to the promoters seeking their PANs. So if you do this and also give us a certificate that the RTA will ensure freezing of this physical shares, we would go ahead and allow trading in these without the PANs.
Okay. Manoj, when you do M&A, what are the problems you are facing for this type of companies which are suspended or suspended and now revival is going on? You do the merger. So what are the problems we are facing?
I haven't come across any specific problem on suspended. It could actually be a good measure, because if the suspended company goes out, and in lieu of that it would get the share of a tradable company, that would be to the benefit of the investors. But I need to look into it how, because currently the schemes, the processing of schemes have actually taken a different dimension altogether at the exchange and at the SEBI end. So if it is an unlisted public company which is going to acquire this suspended company, I don't know how SEBI would view such a company for takeovers. But that would be on a case-to-case basis, how we would look at
Manoj, do you have any point in
Yeah,
this?
so for in case company is suspended, then as per the SEBI master circular, the shares of that company is not the promoter cannot transfer their share for next 3 months from the revocation of suspension. So takeover offer cannot come by SPA, share purchase board. Obviously, through preferential allotment mode, offer can come after revocation of suspension. So that can be the way to change hand or infuse money into the company, but that can happen only after revocation of suspension. So revocation of suspension is precondition. Similarly, for processing of the scheme of arrangement, also suspended company cannot make application for processing the scheme of arrangement. So everything, first step would be revocation of suspension. I think in such case, if stock exchange or SEBI make some relaxation and say that if new group of promoter is coming or someone is ready to infuse fund, because obviously suspension revocation fee is quite high and the existing promoters are not willing or not capable of putting that money, then it may be a easier way to preempt that and allow the putting of the money by new group of investor or new persons. And maybe after putting the money, they may process the application. So some in principle approval from revocation of suspension or something sort of thing can be given. If that happens, it is good. Otherwise, I feel in case of any merger transaction just after revocation of suspension, I don't think there is any challenge. It can be done easily.
Okay, and Gopalji, and you have any point? Manoj is saying something you want to add?
No, I think that is fair. What he's saying is correct, okay. But we need to look into those.
During suspension, can the promoter transfer their share?
No.
No,
It is already frozen, no?
In our company, promoter holding reached 75% due to BIFR order, and the company is suspended. Can the company proceed with MPS compliance during the suspension period, Gopalji?
Who will buy those shares? See, if you are going to do an MPS compliance, you're going to do through one of the methods which are prescribed by SEBI.
Right.
Which public investor will buy the shares in a suspended company without knowing whether this company is going to get revoked or not?
Okay.
See, one thing that they can attempt probably is if they can probably approach SEBI seeking an exemption to go ahead and delist that company, okay, without getting revoked. They can do that. There have been certain companies to which SEBI has granted exemption that you make an offer to your shareholders and you can delist the company even though they are MPS non-compliant. They can probably attempt that. But attempting an MPS in a suspended mode, I don't think it will be a success.
But sir, I think those companies were not suspended at the exchange. All those exchanges, all those companies were tradable at the exchanges, and then only SEBI gave that exemption.
No, I think recently one company has come to us.
Okay.
Yes. So, because if you see the provisions for voluntary delisting of securities, there is no requirement that it should be tradable. But if you see the provisions for small companies under the delisting, it should not be a suspended company. There is a requirement that it should not be a suspended company. So for small companies, you will not be able to get that route. But under the voluntary delisting chapter, you should be able to do this particular attempt. But because it is MPS non-compliant, you would require SEBI's approval for going ahead with the delisting.
Right.
Sir, you are mute.
Palji, this question somebody has asked, but I'm again rephrasing because this is a new type of question has come. My name is appearing as a promoter group in an about 2-week compulsory delisted, while I'm not involved in day-to-day affairs of the company, thereby leading to all the repercussions on me as well. Can I go in for reclassification of my name from promoter group to public?
No, not. See, you need to see. There is. See, for reclassification, you need to follow 31A, but it is not possible in the suspended status. Okay, but probably you can keep your homework ready on how you are being shown as a promoter group entity. I mean, in what way are you classified as a promoter group? Okay, if you strictly, for example, if it is between supposing your name and my name, promoter group is generally if I fall within the definitions given. So generally, for a natural person, it would be a blood relative sort of. But if you are not, then it is, I cannot be called as a promoter group for any other person, right? So if that person can establish that, probably at some point in time later, that can be a ground to say that I should not be shown as a promoter group and I would seek exemption. But currently in suspended status, we don't allow any promoter reclassification.
Okay, because in the past, if you have seen so many cases that people have loosely used promoter group companies.
That is the reason why I pitched afterwards that, you know, please go ahead and see your promoter list, because that is the query we've been receiving quite often, and that is the pain point for many of the investors who have been wrongly shown as promoter or promoter, and then they faced consequences of delisting.
Absolutely. Gopalji, just tell me, the company is, because what is happening, there are so many people, they have joined business together.
Yeah.
And the business has stopped, but their name are there. Okay. So BSE has delisted companies, say in 2005, 6, 7, when you have done the bulk delisting.
Yeah.
And they will continue in the Bombay and National Stock Exchange. And National Stock Exchange has delisted recently. So the period of 10 years will count from the last exchange, or it can be counted from the last exchange?
last exchange.
Okay. And if somebody is proving that because the communication and information has not received to them, because the last address which was there in the stock exchange, that was old address and this office is closed. So whatever communication you have shown, I have not seen. And my settlement has taken place long back, though I have not done reclassification because that time system was not there of reclassification. So any scope for this type of company?
Company for what?
To show that I was not the promoter group. I have already settled long back, 10 years back.
Once it is delisted, we don't have any way to recognize that particular. Actually, we have got one very recent case, which probably when we finally decide on that matter. So we and SEBI are discussing on this issue where one of the promoters of a compulsory delisted company, not knowing that he has been shown as promoter, is actually wanting to come out with an IPO. So once we settle that, probably that would become a precedent in future.
But here this is a case of manipulation that somebody has shown to them, because I have we have recently came out one case where the promoter has sold his entire shareholding to somebody, and that person has sold to another person. But that the new person, because that time the takeover code was using loosely, so the second person has not changed the promoter list, and manipulatedly they were showing all these old people as a promoter.
See, best thing would be to go to the court and get it settled, because exchange and SEBI will not take a decision on this.
Okay. Charu, can you just tell me, in my company there are DNR mismatch, as a result of which the exchange is not proceeding with revocation? Any solution as a professional, what you are doing?
Sir, we can proceed with the splitting of shares, but that is, as Gopi sir said, that corporate actions are not allowed during the period of suspension. Then we may approach exchange in that case, or that has to be taken care after the revocation is done.
Okay. Gopi,
Yes.
What is what if the exchange not if the listed entity failed to comply despite of notice? What is the mechanism to protect retail investor? Any solution is there for them?
The only solution is, like I told you, the trading that is permitted. That's all. Market exit is what is allowed. That's all.
Which is Monday trading is taking place.
Monday trading for 6 months is allowed.
Gopalji, I think this is not known to various people. So if the exchange can promote this particular thing as an investor education, it will be very useful.
Sure. I'll note down this.
Do you have any point which is related to restructuring point of view, which you find that Gopalji can clarify for the benefit of everybody?
Sir, as discussed, in case such companies want to enter into certain arrangement, let's say promoter want to sell the shares, or someone is willing to put money under preferential allotment, then and so that obviously the pending listing fees and revocation fees, etc., can be paid, and the company can be revived. Then maybe some mechanism of in principle approval first, and then putting the money, and then compliance can be made out. That can be one of the way to revive many of the companies, because I have found many of the companies where the existing promoters are not in a position to even pay the suspension revocation fees, which is sometimes maybe 40-45 lakh rupees. So the existing management or promoter has no capacity, but the new person may be interested to take advantage of listing and come into the company. So that kind of thing, I think, can be a good solution.
I think we can look at that. We need to look at with open eyes. I mean, open mind. So,
Anjali, you have any specific point which, on behalf of everyone, you can ask?
I think what Manoj said, if somebody else is willing to put in money, either in the form of a preferential issue or somebody is willing to take over the company, even if it is suspended, if it can be allowed, it will be a win-win situation for both the company and the shareholders, and it will be the benefit of the investors at large.
Okay, Gopalji, if the company
Yeah.
is delisted by the exchange,
Yeah.
but in few cases we have seen, in 1 and 2 cases, the SET has allowed them, and they said that delisting process is not complied.
Correct. This is what I told you, that SAT had remanded those cases back to the exchange. So we then issued the, we followed the process once again, right from issuance of show cause notice. So we had to follow that entire process once again. And that was a time when we had this COVID hitting us in 20 and 21. And so many of these companies said, you need to give us time, even though SAT has remanded back. So we gave them time, mainly on compassionate grounds. But now we have taken it up once again for delisting of those companies if they have not complied during the last 1 year.
Gopalji, is it possible? That's a very funny question I'm asking. That, like in OTS, a person is in a bad shape. He is going to the bank and saying, this is the new buyer, and he will pay entire money and settle with them. Same type of thing stock exchange can do, that I am the promoter of a company which is suspended, and I don't have money, I don't want to run, and I don't have money to pay the other shareholders also. So I can bring out a new buyer, a new acquirer, and then he is saying, I will pay entire fees and other thing, and I will comply. Stock exchange can consider something positively?
Yes. Like Manoj, this was Manoj's proposal, right? So I think we need to look at it with open mind. I think that should be doable. Okay,
I have given a suggestion to long back to SEBI and other people that make the listed company as a commodity. Like you have a stock exchange membership of broker, and the broker is defaulted. You are selling that, you are doing auctioning of that particular ticket. Okay, and that ticket you are selling to somebody, like Ketan Parekh ticket you have sold to somebody. You have sold the any defaulter who's a scamster. But stock exchange is doing auction of that ticket, and other person is buying, and he's buying with purity, with no liability attached with this. Can't we do something to the stock, to these listed company also? Make it a commodity. Anybody wants to buy, he can do this, because that will save in lots of investors.
No, the issue here is that especially in the broking space, that ticket concept is now gone. That card no more. Now it is a deposit-based membership. Yeah. For companies, it is anyway available for sale. Anybody can buy that company, or you have the IBC process through which also you get a clean takeover of these companies, because you get a lot of exemptions out there. A lot of past liabilities, compliances get wiped out. Okay, so I think IBC would be a much cleaner process to get yourself reinstated onto the exchange.
I think, sir, yes. Now under IBC there is a possibility of voluntary invocation of IBC by the company itself. If the existing company feels that they have no money to survive, or no business to carry, or major there are losses, they can voluntarily pass resolution under section 10 and admit the company into insolvency, and later on it may be change hand. So that is a possibility now.
Yeah.
Okay. So I think we have given all the answer. I think one question, last question I can cover, which is.
Sorry, I lost you. You're not audible.
No. I think this question is not, they are saying thank you. There's no question. So I think all the questions which we have received, and all the questions which we have received earlier, Gopalji has given answer of all the questions. That's why I said you that he's Sachin Tendulkar of this space.
Hey, Pawanji, please.
No, Gopalji, not. I'll tell you. the way you have a knowledge and the way you have a exchange the logical point, that is a very remarkable point. And the way you have given answer of all logic with legal background, that is a remarkable thing. So friends, I thanks on behalf of everybody, Gopiji, for this. That's why I was waiting to call him for earlier program also, but he has come today because SEBI's meeting was clashing. So now the SEBI meeting has taken place by physical mode, by online mode. So he has attended this program. So thank you very much, Gopiji. Thank you, Charu.
Thank you. Thanks, Anjali.
Thank you, sir.
Thank you.
It was
Thanks.
pleasure having you.
Thank you, everyone.
Thanks, Manoj.
you, sir.
And
Thank you, sir.
nice meeting you. And
Thank you,
Charu,
sir.
you too. Yeah, thanks. Bye.
What we will do, Gopiji, just 1 minute. What we'll do,
Yeah.
all these questions which we have received and suggestion, we will send it to you. So
Yeah.
anything you can take up this matter and
Sure.
you can give clarification like I told you. that
Yes. Please.
This matter,
I think Gopi sir has already replied to almost 20, more than 20 people on their questions online during this discussion itself. So those are also very useful. We can compile those questions and answers and can be useful.
Please send it across. We'll satisfy all the questions. No problem.
Thank you very much, sir.
Thank you. Thanks, Manoj. Yeah.
Thank you, friends. So friends,
Thank you, sir.
this knowledge sharing will continue as we are doing webinar on every Friday and 4 to 6. So our next webinar, as you are aware that on Monday, the first Friday of the month, we are doing updation of last month to this particular Friday. Whatever new changes in company law, SEBI law, and the IBC as well as the FEMA law. So this Friday on 2nd, we are discussing updation on SEBI and companies law. That is very limited, but the major changes come in overseas investment scheme by RBI. So we are discussing in detail these overseas investment scheme which RBI has announced, and that is a game changer in various aspects, and we will discuss threadbare, and I have requested ED of RBI to be the chief guest for this program, and we will discuss the entire issue. So thank you very much. See you next Friday at 4 o'clock. Thank you very much.
Thank you.
Gopinath.
Thank you.
Thank you.